Our president and my good friend Mary Smith just arrived back. She, for those that were here earlier, she gave some general remarks and is going to come up in a moment to introduce this program. I'm Dan Cotter. I'm president-elect of NCBP and programming chair for this year, and so want to thank all of the programming committee members that have put together hundreds of hours of time and energy to make this program over the last 48 hours. I hope you agree. Very valuable, with a lot of takeaways, a lot of good discussions and thoughts. So with that, we'll start the program. Thank you, Mary, for all your work on behalf of the organized bar. We appreciate very much all that you're doing to ensure that democracy and other rule of law issues are being addressed, and for your nonstop travel and visits to bar leaders and bars around the country. We don't know how you do it, but I'm glad it's not me. We all know that artificial intelligence has woven its way through almost every aspect of our lives, but as lawyers and bar leaders, we need to ensure that we ourselves, as well as our bars and our members, are using it safely and ethically. And you'll hear about, and you've seen a lot of hallucinations and other things, and so we'll get into some of that. Today's program is a joint effort between the NCBP and the ABA Presidential Task Force on Law and Artificial Intelligence. In a moment, I'm going to invite Mary to come back up to provide introductory remarks, to be followed by Ted Claypool, Vice Chair of the Task Force, giving an overview of the task force's work. But before I do that, let me explain how the program will flow, since we have a number of experts here to give you a crash course on AI issues you need to watch and be familiar with. The program will be broken up into two parts. During the first half, moderator Tricia Rich, immediate past president of the Association of Professional Responsibility Lawyers and an NCBP program committee member, will set the stage for three of our panelists to do many presentations on the uses of AI by bar associations and lawyers, and then guide a conversation among them. Our panelists for this segment are Julie Chapman, Head of Legal in North America for LexisNexis, Damien Riel, Chair of the Minnesota State Bar Working Group on AI, and Lisa R. Lifshitz, Director and past President of the Canadian Technology Law Association. In the second half of the program, Tricia will bring our second set of panelists up to do many presentations on the ethics, misinformation, and misuse surrounding AI, followed again by group discussion moderated by Tricia. Our panelists for this segment are Mary Baldwin, Board of Directors for the Association of Professional Responsibility Lawyers and past president of the Bar Association of San Francisco, Ted Claypool, and Lucy Thompson, chair of the ABA Presidential Task Force on Law and Artificial Intelligence. I'd now like to invite Mary Smith, ABA president, back to the stage to introduce this important program. Thank you.
Well, I'm back. Thank you all. This is such a great program, and before we start, that's going to cover so many topics, and there's so many experts on this program, so glad you all are here. Before I start, I just want to thank some of the people who really helped get this program together, Beth Cheng from NCBP, and Teresa Peavy, and then, of course, Joey Gartner from the ABA, so thank you to the three of them who really kept us all on track. Artificial intelligence is one of the most transformational technological developments of our generation. For the first time, computers have the ability to mimic human thought by processing large quantities of data to make predicted outcomes. Over the past year, the widespread adoption of AI in all facets of life promises to transform how we will all live and work. AI is a useful tool to automate mundane tasks, improve productivity, and engage in rapid-fire decision-making by assimilating large quantities of data. Businesses, schools, governments, and individuals have all tapped its potential. With such widespread use, AI is transforming every industry sector, including the legal profession. The ABA Presidential Task Force on Law and Artificial Intelligence brings together lawyers and resources from across the ABA to address the impact of AI on the legal profession and the practice of law. I invite you to explore the task force webinars, articles, and news updates from across the ABA that are available on the task force website. These materials offer valuable insights on emerging legal risks from the use of AI and on how to use AI in a trustworthy and responsible manner. Despite its promise, AI also presents novel challenges with complex legal and ethical questions. The AI Task Force is undertaking thoughtful research and analysis in a rapidly shifting regulatory environment. It is convening stakeholders across the profession to identify key concerns and issues. The task force has 7 dedicated working groups, which I'm sure you'll hear more about today, engaging the views of ethicists, judges, access to justice advocates, academics, and lawyers, working across all sectors of the U.S. economy. These teams are developing materials and recommendations for responsible and trustworthy adoption of AI tools and technology by the legal profession. And the work of the task force will culminate at the annual meeting in Chicago with an authoritative report to inform ABA members and the public about the impact of AI on law and policy. I hope you will join me at these upcoming programs, and you must come to the ABA annual meeting. I have several members of the host committee, including your very own Dan Cotter, and at the end of each meeting I say it's going to be the best meeting ever, so you have to be there. And so this is just, I thank all of you for all your work on AI, and this is, I think, going to be a spectacular program, so thank you all.
Thank you, Mary. She said everything I was going to say. So, no, the one thing, I have 2 minutes. So to say about the task force, this is truly a presidential task force. In other words, the things that we're doing, Mary should get credit for because she really has been active and as a technician herself, trained in this area. She really helps us and knows what she's talking about in this space. So we give her all the credit for everything we're doing. We're very fortunate. You're going to hear later today from Lucy Thompson, and Lucy is the chair of this task force. Just quickly, the task force has a number of members and then a number of advisors. Many of them are technologists. Some of them are ethicists. Almost all of them are lawyers, many are jurists. So we try and find people from all over the spectrum who can help and have knowledge and interest in this area. The couple things I wanted to highlight that we're doing, on one hand, we have a website, as Mary said, and we are collecting information and the activities of the rest of the bar and the state bars. We would love to hear from you in your state if you have AI projects going on. And we actually are doing some work with some international bars as well in the UK and Japan. We're able to talk to others who are active in this space. On the other hand, we're doing our own projects. The one that I want to highlight is that we have a judicial committee that is made up of academics and judges who are taking a look at a number of things that are happening online and with the courts and how they can influence policy in this space. So there is a lot more that we're doing. I don't really have time to go into all of it, but come up, ask Lucy, ask me, ask Mary, because we're all very excited to talk about it. Thank you for being here today.
We are already about 4 minutes behind schedule, which I promised Beth would not happen. So very briefly, welcome. Thank you to my good friends Dan and Mary for those introductory remarks. As Dan mentioned when he was up here, my name's Trish. I'm the immediate past president of the Association of Professional Responsibility Lawyers. I'm a legal ethicist. And joining me for this first session are Lisa and Julie and Damien. Julie is going to, I already made a mistake. Julie is going to start us out. So we're going to do 3 presentations, 15 minutes of questions, potentially a short break, and then we're going to do it again. But we're starting with use cases. Go ahead, Julie.
Okay, I will move up there and hopefully not fall off the back of the stage. See if this works. There we go. Thank you very much for the introduction and for having me today. So I'm just going to kick us off by, this is sort of what we're going to go through, is give you just some idea or some suggestions on how you can approach, potentially integrating generative AI tools into your legal practice. Before I get started, though, on the agenda, just wanted to mention that I spent the last week in New York City at Legal Week. I know a few other people in this room did as well. And I kind of expanded what I wanted to talk about, or maybe I should even say tailored what I wanted to talk about based on those discussions. It was incredibly interesting. And over at that, 3.5-day conference, there were a number of sessions, and I would say almost all of them had something to do with generative AI. So it's absolutely a topic that everyone needs to talk about. I just want to make it clear today that you don't have to jump all in all at once. So that's what I'm going to try to discuss, is sort of general approach. So we'll start with talking about low-value legal work. And I know we've talked about this for years. A lot of lawyers, and this is in-house lawyers in particular in that one quote, feel like they spend a lot of time doing lower value, often higher volume work, when what they were trained to do, and usually what they would like to do and their business partners would like them to do, is be more involved in things that are strategic, higher value, getting to know the business, understanding their pain points, being in the room, that sort of thing. When you spend too much time on lower value legal work, you, again, have limited ability to do all those other things that you want to do because you get kind of buried in your day. And you get the task done, the day is over, and you think, oh my gosh, where did the day go? So I would like to talk to you today more about moving up the value chain within the legal function. And this is a good starting point, I think, to look at how generative AI could potentially help you do that. So just some examples here of what I would describe as low-value work. Summarizing a case or a contract. So if you think about that, you have a contract, there's a whole bunch of terms there. You would potentially in the past at a law firm ask an associate or a student to give you a summary of that contract, major terms, term, indemnification, warranties, those sorts of things. Summarize that. Well, there are tools to help you do that now. You don't necessarily need to spend too much time on it. Drafting, initial drafting, especially when we're talking about sort of first drafts. There are a tremendous amount of opportunities now with starting points there. Document compare, crazy enough that I feel like I have to mention this, but I find that that's still a problem where people are just wanting to create a black line of a document. And that actually takes more time than maybe it should. So these are, again, I've already mentioned these. I won't go over them again because we have limited time. But these are some examples of high-value work that I would suggest many of us, especially more senior level lawyers, would prefer to spend our time doing, and so would our clients. So this is where I want to focus my presentation on, is how generative AI will actually help you get there. So one of the things, I guess I'll start with the past year, which was very intense for me personally in my role as head of legal at a legal technology company. So back in, I would say, it was the first quarter of 2023 when everyone saw what ChatGPT could do. We were lucky enough to have a CEO who recognized what that could possibly mean for the legal industry. And I can tell you that our strategies at that time and our plans for that year got thrown out the window. And we said, we're going to develop the first legal product, with generative AI product for the market. and this is what everyone's going to focus on. So that became my life. And I would say 2023 in general was kind of a proof of concept year, where it was like, okay, so let's just, is this a real thing? Is this really going to change our day-to-day work, or is it just hype? I would suggest to everyone in this room that this is a big deal. This is something you don't want to ignore, or you're probably going to get left behind. So this year is more the year for adoption, I would say. And where do you start? I mean, where do you start in looking at what you can do with these tools? And one of the things that was talked about quite a bit in the past week is that you still always want to start with a strategy, right? So the reason I introduced the concept of low value and high value work is all of our organizations, our firms, they're different. And you want to look and go, okay, take an assessment and go, what is the low value work that maybe we could try to take away off our hands, at least those first drafts, as I said. And it really is going to depend as well on your sort of risk comfort levels in your organization. So you don't have to just go all in and be like, we're going to try to do first drafts of everything using this generative AI tool and go from there. No, I mean, I wouldn't suggest that. I would say that you start with something that's a little less risky and where hallucinations are going to cause you less problems. So you wouldn't want to necessarily do what has been done, and we've seen in the news, where you are just asking a generative AI tool to provide you with a number of citations to cases, and then without actually checking that those cases actually exist, submitting them to a court. That would be a higher risk use case, I would suggest. So you may want to start, again, with the first draft. So, for example, I'll tell you what I use it for, or I have started using it for, and my team does as well. Things like cease and desist letters, right? So we have quite a few situations where we discover that someone is using our content without a license, and we want to send a letter to ask them to stop doing that. Well, I can honestly use our tool to say, draft me a cease and desist letter to such and such individual and telling them to stop doing this. And within 30 seconds, I will get a draft. And I would not just say, okay, here you go, and send the draft off, obviously. That's not the point. I would read the letter, make sure it's accurate, send it out. So I can tell you that I would say on my team now, out of probably, I don't know, personally I would say that I've done that about 5 times. Let's say cease and desist letters. It's worked every time. They've responded and they've stopped doing what I asked them to do. So it was a time saver, absolutely, and it was able to provide a very good first draft. Again, pretty low risk. I would start with those sorts of things. So the other thing to make sure, as a lawyer in a corporation or a law firm, I mean, you want to make sure when people are looking to determine whether or not they should acquire a generative AI technology or maybe develop it internally, which some firms and corporations are doing, that they are, again, thinking about strategy. What is it we're trying to actually do here? Let's make sure we involve the right stakeholders. One of the things that I find that often in-house legal departments maybe have a miss on when trying to bring in a new technological solution is they don't consult with their stakeholders to make sure that everyone is on board. So because adoption is going to be so important with any sort of technology, you want to take the step back and involve everyone in the process and make sure that whatever tool it is, again, that you're acquiring or developing, is going to be useful for the people that actually have to work with it every day. So that would be another suggestion that I would give you.
I think we're going to actually, stop there and switch to, excuse me, Damien, sorry, I'm getting over a cold, and do our first transition.
Sure.
All right.
There you go.
And on the topic of, you could take the boy out of federal court, but you can't take it out of the boy, so I'm not going to go past the red light. The red light will let me know if my 9 minutes are up.
That's right, I got it. It's good.
My name is Damien Reel. I've been a lawyer since 2002. I worked for state appellate judges as well as federal district court judges, and the Article III judge that I worked for really led me to working for Robbins Kaplan. Robbins Kaplan is a large law firm where I worked for 15 years representing Best Buy in much of Best Buy's commercial litigation. I represented victims of Bernie Madoff. I also sued JP Morgan over the mortgage-backed security crisis. So I did high-stakes financial litigation and business litigation. I've also been a coder since '85. My mom loves this photo. This is the Commodore 128 that I used when I was coding in 1985. The number of lawyers that are also big law refugees, that are also judicial clerks, that also know technology, there aren't a lot of people in that Venn diagram. I'm one of those. In 2015, I left the practice of law to say to TR, hey, here's some legal tech that can change the world. You should build it and hire me. And they were stupid enough to do that. So I led a team of 100 programmers and 50 lawyers building this really big thing for TR. I left that cool job to do another cool job in cybersecurity, where my company was hired by Facebook to investigate Cambridge Analytica. So I spent Monday through Friday on Facebook's campus with Facebook's data scientists and my former FBI, CIA, NSA people working with me, figuring out how bad guys use Facebook data. I did that Monday through Friday for about 57 weeks in a row. The stuff we did on Monday would make the New York Times and the Times of London by Friday. I did a music thing. I've copyrighted 471 billion melodies. It's been seen 2 million times, including by Elon Musk, who thinks I rock, apparently. My friend says Elon Musk has horrible judgment in all areas, except for one. He got this one right. These days, I lead up VLEX. There are data science, where I have 1 billion legal documents, where I parse them with data science and use large language models. And I also help lead the legal data standard called SALLY. SALLY is, we're applying for ISO standard. We are a standard to make Lexis and Thomson Reuters and VLEX and iManage and all of your law firms interoperate with data. I help lead that initiative. But here I'm with a different hat, where I'm actually part of the Minnesota State Bar Association has asked me to chair a working group to determine whether AI is or is not the unauthorized practice of law, and also to assess access to justice issues for these things. And I've also consulted with the ABA on such things. So, of course, why are we here? We're here because this is a big deal. We're here because in December of 22, GPT 3.5 beat 10% of humans on the bar exam. Not super impressive, but more impressive is GPT 4, which beat 90% of humans on the bar exam. Let me repeat. GPT 4 beat 90% of humans on the bar exam. That was in March of 23. They're building GPT 5. How many will GPT 5 build? How many? This is why we're talking about this here. The Chief Justice knows this is a big deal, and especially with access to justice, say that it can answer basic questions. And by the way, there's a mismatch between people that can hire us and not. 80% of legal needs are unmet because they can't afford the people in this room. What do we need to do? As a litigator, I would always make counterarguments and good facts. So I thought it'd be fun to take where a bunch of coders have sued Microsoft and OpenAI over a bunch of code that they uploaded. And the code was ingested by Microsoft and OpenAI for an AI tool called GitHub Copilot. And so the coders are like, hey, this is MIT licensed. You breached a contract. So I thought it'd be fun to have OpenAI be argued against by its child, ChatGPT, where I said, hey, here's OpenAI's motion to dismiss. Give me some counter arguments. I didn't upload the entire thing. All I did was the table of contents. And even with the table of contents, it said, hey, OpenAI said you lack standing. ChatGPT responded saying, no, they have standing. Kind of cute, right? It flipped it. But then the next one, it said, give me the elements of each of the claims. And they said, well, to show standing, you have to show injury in fact. It's traceable to conduct, and a court decision is likely to address these. These are the actual non-hallucinated elements of the claim of standing. Then I said, for each of those elements, give me some facts to be able to show that the plaintiff satisfied those elements. You could show that they suffered economic harm, that the coders lost revenue, that the coders incurred costs. Each of these is something that you can imagine is a legal task, that I would be able to give a questionnaire to my clients saying, how have you suffered harm? How have you incurred costs? Then I said, okay, where you say it's a direct cause, give me some factual examples of how a large language model, ChatGPT, could cause the coders to lose money. And here it said, you could argue that the copyrighted work without obtaining permission caused me as a coder to lose revenue from licensing it to other companies. This is a good legal argument to show standing. ChatGPT also said, hey, you competed directly with my own coding services, causing me to lose clients and revenue. This is a good legal argument. The large language model also said, hey, this code was similar enough to my code to cause confusion in the marketplace, causing me to lose sales. I have standing. This is a good legal argument. Everything I've shown you took me less than 1 minute. This is why we're here today. This is not, oh, ChatGPT isn't quite here yet. How long would that have taken an associate to do? If that associate charges $500 an hour, maybe they charge 8 hours, how are you going to charge for my 45 seconds of prompting? And you might say, well, I'm not a prompt engineer, Damien. I can't do it like you. What if you led a team of legal software builders to make this a button so you don't have to be a prompt engineer? You just hit a button and this comes out. This is why we're talking here today. This is not a flash in the pan. We've talked about the death of the billable hour for many years. This might be the thing that makes it happen. Think about access to justice and equal justice. Who, by show of hands, disagrees with this argument that we should have equal justice for the rich and the poor? Right? Obvious. Of course, no one owns the law. Everyone should have access to the law. The richest of the poor, everyone should have access to the law, according to the Supreme Court. Right? No one disagrees with that. So when we say let's take these things down, how are we going to do that? Because what is the difference between legal information and legal advice? That's the essence of the unauthorized practice of law statutes. What is the difference? And I would challenge each of you to think about what the difference is. Because is this legal information or legal advice? Obviously legal information, right? Everyone, the rich and the poor, should have access to these cases. Then if you ask Google, what's the elements of a breach of contract claim? Is that legal information or is that legal advice? Obviously legal information, right? Especially since at the bottom, a lawyer on his website gave the elements of those claims, right? So is the lawyer committing unauthorized practice of law? No, of course not, right? This is legal information. Then you ask Google, within Google Docs, give me the elements of a breach of contract claim under New York law. And then also ask, draft a motion to dismiss for the Southern District of New York for breach of contract under New York law. The question is, will the consumer think that this Google is acting as their lawyer? No. And just like beauty is in the eye of the beholder, whether somebody is representing someone is also in the eye of the consumer. Is the client think that this is a lawyer giving legal advice? And if the answer is no, it's not legal advice. Microsoft, what are the elements of breach of contract claim under New York law? In Word, you can ask, draft a motion for Southern District of New York. You can do that in Google. You can do that in Microsoft. You can obviously also do that in ChatGPT and OpenAI, which partners with Microsoft and has the biggest funding and biggest consumer in the world. So really the difference between legal information and legal advice is shrinking dramatically, if there has ever been a distinction. So really, should the rich and the poor have access to this? Are you going to take down Microsoft? Are you going to take down Google? This is the question that we have to assess as bars. So between the rich and the poor, also the rich have Westlaw, the rich have Lexis, the rich have VLEX. We're all using large language models. What do the poor get? The poor use Google Scholar. That's the difference. So really, as we think about, we as lawyers in this room have access to Thomson Reuters, Lexis, VLEX. What does the rich have? They're Googling. They're using Google Docs. They're using Microsoft Word. So really, are we going to say, hey, poor people, you get the bad stuff. We as the lawyers get the good stuff, but this is an access to justice issue. And when have we been able to slow technology? I'm old enough to say, to know that when we initially had email, people would say, you can't use email because you can eavesdrop on these things, right? Everybody used it. Now it's totally okay. Don't use mobile phones because every hop along the cellular tower, you can eavesdrop. Everybody used it. It's now okay. We can't use the cloud, right? Because it's not within my premises, so no, everybody used it. Now it's fine. What next? This is the way it's going to happen. So with that access to justice, if you'll give me 30 seconds, this is an access to justice issue.
I'll permit it.
Where Jane can't afford a lawyer. She makes $1,000 more than legal aid cutoff. In the old world, she said, I'm either not going to sue or I'm going to use Google as my lawyer. The complaint's going to be bad. The motion to dismiss is going to be bad. The judge is going to pat her on the head and say, nice try, but it goes away. There are things called procedural rules. That's the old world. But the new world, she can either not sue or use a large language model. Complaint's going to be really good because it's a valid claim. And the motion to dismiss is actually going to be pretty good because she's got a valid claim. And the court's not going to be able to pat her on the head and say, go away, because, again, this is a valid claim. So not only are there going to be more Janes filing these things, as there should be, because, again, she has a valid claim. Now she has access to justice. But there will be more Janes in the pipeline. And so this is a way that we need our courts to be able to use large language models to work through that pipeline, to give Jane the access to justice that she deserves. And so this is really, between the rich and the poor, the tools are not just for the rich. This is an access to justice question. So the question is, are we going to prosecute Microsoft and Google? And who does we serve, the public or the guild? Thank you.
Thank you so much. All right, and finally, Lisa.
The arrow. Yeah, green arrow.
Okay. Good morning, everyone. Not sure I can see over the podium, so I'm going to do it from here. Absolutely delighted to be here. My name is Lisa Lifshitz. I'm a partner at Torkin Mays in Toronto. And I'm going to talk about how you actually contract for AI solutions and products. In the 9 minutes I have with you, I'm going to give my best to try to laser focus on the key issues of contracting and negotiation. Giving you my initial observations, I'm a proud member of the AI task force. I had the opportunity to read like 75 of these contracts in that capacity, so I'm going to try to pass along my knowledge. Then I'm going to talk about some critical threshold questions you need to ask if you're doing this. Then I'm stress the importance of due diligence, laser focus on the hot button issues that everyone should look at in these contracts, and then hopefully offer some AI risk mitigation strategies and conclusions. So, it's fair to say that AI products and solutions are complex and have a very contracting framework. The challenge is both these services and the contracts are subject to constant modification and change. There's at least one slide in this deck that's already out of date, and I didn't have a chance to update it by the time I submitted these PowerPoints. So the challenge is that, in my view, it's very early days in AI contracts. It's like the early days of cloud computing. The contracts are very one-sided. They attempt to shift and allocate all the risks to the clients, and things like limitation of liability. So I do believe, and I'll say at the end, that the contracts are going to evolve, but it's early days right now. So it's very much a constant conversation between what you need to add in and what you need to pull out. So one of the issues, for example, is that, just by way of example, a lot of the contracts are missing very critical information around AI critical performance considerations such as model maintenance, obligations to maintain the model, what happens if the model changes, any obligations on the vendor to actually monitor and maintain their model. There's also concerns around a focus on you can't audit these contracts. They're quiet on very critical risks like risks to client confidentiality and cyber threats. They don't actually talk about breach notification requirements. There's a lot of disclaimers involving reliability and accuracy of outputs. And there's really heavy emphasis on client responsibility. So there's a couple of themes I'm going to be touching on. Heavy emphasis on client responsibility is one of them. So some key threshold questions, and this is really important, whether you're counseling your own clients, whether lawyers are using these systems internally. What kind of AI system are you getting? Are you going to be using sort of standard off-the-shelf AI that has no bespoke customizations and you're relying pretty much on the vendor to run it using vendor data? Or are you engaging in a bespoke arrangement where the vendor trains and customizes the AI system? If you are in number two, you have more opportunity to influence the contract terms, but I'm going to argue it's really imperative on all of us lawyers, the same way that we help move cloud computing contracts into something people that can sign. It's really important for us to push back on the market and try to tilt the contracts to a more fair balance, even in the off-the-shelf contracts. You also have to ask what kind of services the AI system will provide, who's going to train the tool with what data, will the systems be used internally or externally, will the solution maker affect regulated decisions, and which laws apply to those services, and very critical threshold question as well, will it involve the processing of PII, or PI as we say in Canada, and what control will clients and users have over the AI systems? Equally important is you have to understand your vendor and do your due diligence. Is your vendor a relatively mature company or is it a startup? Are you reading about your vendor? Are you reading about case law involving your vendor? Has it been the subject of FTC claims or other privacy regulation claims? Where's the data coming from? What do the vendors say where the data are coming from? Are they scraping it from the internet or are they publicly saying they have the right to use their data? Was it created for somebody trustworthy like a government agency? You have to understand, some of these products may not be appropriate for lawyers, so that's part of really the analysis. You also have, before diving into the contract terms, you have to understand the use case, the nature of the intended application, and what laws will apply. The other thing is you have to look at the framework. I consider these contracts like baklava. They're very flaky. They have lots of layers. Terms of conditions, terms of service, hyperlinked license agreements, additional terms. They separate out the business ones from the free ones. Websites, privacy policies, bippity boppity boo, okay? But the thing is, you have to read all this stuff because that's what you end up getting the actual picture. So again, and the other interesting thing is, like I said, these change all the time and there's no obligations whatsoever for the vendors to make you aware of that. So part of the challenge is even figuring out which terms apply to the service. So, hot button issues. You got to understand what the rights are in terms of what you're buying. Do the rights meet the requirements you need? Does it allow you to create derivative works if you needed to? You have to drill down into the license grants because, frankly, there are some contracts that have geographic limitations. Some have limited uses of certain elements of the AI. You have to talk about the data training sets, which I mentioned before. And the other side of that is you also have to understand what is the vendor going to do with your data. It's typical that vendors want to use your data to improve and fine-tune their algorithms, but what does that say about putting client confidential in there? Are they going to anonymize it? So you have to understand what the vendor's actually going to do with your data as well, and is it okay depending on what they say or don't say. You also have to do a deep dive into the cybersecurity and privacy elements of these contracts. What do the vendors say about their own practices? Again, you have to look at the plethora of documents that make that up and put in those critical elements that you need in order to make sure you comply or your client complies with your obligations. For example, you need to know about mandatory breach. You need to add mandatory breach notification. And what do they say about how they use PII? And look at their data retention policies. And also, what do they do with your prompts and how do they protect your data and their information? And you have to look at that through the supply chain. Again, be careful of those reverse requirements. A lot of these contracts are all about what you say you're going to do. So, for example, you have to rep and warrant that you have the ability to put these, to use your data and to use the system. You have to comply with their acceptable use policy. So again, if only one of the things you take away from this presentation is make sure you minimize all those reverse onus requirements. Speaking of reps and warranties, these are terrible contracts. They're all as available. If you're lucky, you get direct damages. There's no reps or warranties. They disclaim everything. So again, that's a fertile area for you to look at and make changes to. You also have to make sure that, again, like I said, they're asking you to give all these reps and warranties. So it's really important for you to deal with that. Okay, I don't have time to get into what the critical ones are, but obviously they're and you can get these slides, but compliance with law, no infringement, no past or present misuse. You can read my slides. Okay, lots of disclaimers. Typically, these are very, very low value contracts in terms of what the vendor's going to give you. If you're lucky, you get $100 or you get some of your fees back. So again, really dive carefully when you're talking about potentially millions of dollars worth of data or other things. And of course, what you want is you want to make sure that the products themselves, that you are getting what you need and putting in appropriate super caps where necessary for breaches of confidential information, for breaches of client information, for data loss, fraud, gross negligence, the usual sorts of things. With respect to indemnities, these are hilarious, or as hilarious as what a lawyer would call it. Generally, they're all reverse. It's all about what you're giving to the vendors, right? You're defending them. You're defending them of your use of their system. You're defending them of anything you do with it. So obviously, you have to try to minimize these, and you don't want to be responsible for global infringement claims. On the other hand, there is hope. You are starting to see some evolution in the market already. In the beginning, there was no, for example, indemnities for IP infringement. Now a number of the large vendors are actually giving you that. They recognize these contracts are untenable. But obviously, there's other indemnities that you're looking for, things like breach of laws and other sort of critical areas. Lastly, termination considerations. I could go on about this, but it's really important to understand because these contracts can be often terminated very easily. What happens with your data? What happens with your client's data? What happens to the outputs? Do you have an ongoing right to use anything you've actually created with these contracts? It's really critical, particularly as lawyers, to protect client data because we have found out, for example, it's not that hard to reverse engineer some of these things and client data becomes visible. So, just to conclude this whirlwind tour, and by the way, I have a version of this presentation that's 45 minutes, so you can appreciate there's a lot of things I didn't have a chance to cover. While there are very many benefits of using AI, it's really imperative that lawyers assess the risks of the individual tools and solutions and deploy the appropriate mitigation strategies that they need to use it safely and legally. And it's really important to start to push the market. Again, a lot of these things feel like the vendors are intending to try to make it look like you can't negotiate them. But that's not true. If we all had, $1 for every contract we were told we couldn't negotiate, we wouldn't have careers in this room. So, and some vendors are better than others. So that goes back to the issue of the due diligence and really doing your homework. And you also want to understand what you're getting, so try to make sure you have contractual transparency. And like I said, look for those vendors that are starting to differentiate themselves. The other reality is, as much as it's tempting to use generative AI and sort of ChatGPT, that may not be the right thing to be using as lawyers, particularly for client-focused, depending on what we're doing with the particular software. It may not be the right way to draft those contracts. There are certain kinds of legal-oriented tools, for example, that may be more appropriate, depending on the nature of how it's being used. And the hopeful message here, because when I've always been told you should end off hopefully, that it is early days. I do believe that we as lawyers have a duty to try to make sure the market moves on this, and I do believe these contracts will evolve in the face of market pressure.
Thank you. Thank you so much. Thank you to our first three speakers. I think we're doing okay on time, so we have some time for some questions. We have a block built in now for that. So there's two people with microphones wandering around. If you have a question, go ahead and wave your arms wildly at me. But I will start by tossing out a question to the panel. Thank you. If you are a bar leader in this audience and you're going back to your home state and there are people in your bar association asking, like, how do I get started, right? What's the first thing I do? How do I even work ChatGPT, which is, I think, or generative AI, which is what I think some of us are hearing now back home. What's a good way for us to tell our constituents how to start dipping their toes into this?
I would say use it. There's a free version of ChatGPT you can use right now. Bard is free. There are all sorts of ways that you can dig in to be able to do the things I just demonstrated. And once people start to use it, then they think about four implications. One, how does that change the substance of law? Number two, how does this change the business of law? Number three, how does this be able to change access to justice? And number four, does this implicate the unauthorized practice of law? So those are the four things that I would say: substantive law, business of law, access to justice, and UPL. Those are ways to get started.
Julie?
And I was going to mention the fact that I found it interesting this past week that when we did a survey in the room during one of the sessions, that a lot of companies seem to have just taken the sort of, we're banning the use of generative AI tools in your work right now. I think that's a mistake. However, that doesn't mean you can't try it on your own, right? I think you have to try it. I think you have a fiduciary duty as a lawyer to provide your clients with efficient and effective work product. You can't just do what you've always done if there are tools out there that would allow you to do things in a more cost-effective and potentially even more useful way. So for me, it would be if your company's not willing to let you try it officially yet, try it on your own, get used to it, try to get comfortable with it, and then go from there. Because I really do think there will be a pretty heavy shift towards acknowledging we have to try it.
I'm going to get to you, Lisa, in 1 second, but I want to make a comment about what you just said, Julie. So I'm a legal ethicist. I am outside counsel to a lot of different kinds of law firms, and I've spent a lot of people do what I do. Have spent a lot of time this year writing AI policies for law firms, and I've written basically two kinds. The first kind is don't think about it, don't ever look at it, don't read anything about it, pretend it doesn't exist.
Head in the sand.
Yeah, and the second kind has been a more moderated take, which is we have to figure out ways to use it, maybe start with marketing pieces, which is a suggestion I would give, and how I started using it was just I used it to develop a PowerPoint on AI that I gave a couple of weeks ago at PLI in New York. So it was actually this great moment at the end, and I was like, how can you use it? Well, I built this PowerPoint. But The second kind of policy is like figure out ways to use it, but don't put confidential client information into it yet. And I've mostly written the first kind, and I've been glad every one of those I've gotten, because I've been like, you'll be back next year. That has been my thought. Like, you can't stop this train. You are going to pay for me to write you a new policy next year, and I'll see you then.
Right.
And that's, I think, what you're saying, right?
Yes.
Yeah.
I completely agree.
Yeah.
Yeah, and I would comment two things. Number one, at the risk of, I have to preserve my practice, I don't just beat up on vendors, I act for vendors too. But the reality is that there's a lot more to AI than ChatGPT, and I think we're doing it a disservice. Generative AI is sort of the overall category that we're talking about, right? So there are very bespoke tools out there, very precise elements that we could acquire or we could test to you, and using ChatGPT is like the public one, right? So I don't necessarily recommend using that for your legal practice. That being said, there are some excellent products out there that are a lot more relevant and have been, tested using data that, the companies themselves say they have the legal rights to. So I think that's really something I want to focus on and say that, you have to choose carefully, choose wisely. I mean, you can use ChatGPT to draft a condolence notice, or something like that. But the other comment I would make is, being an egotist, I fed my own bio. I wanted to ask ChatGPT about myself. So it got my practice area wrong, and it made up a bunch of articles that I never wrote. And the other thing it also did is it gave me different universities that I went to. So
Too. I did the same.
exactly.
It was
So
completely wrong.
exactly, totally wrong. So, but I like some of the things it said. So So I entreat you, if you're looking for a way to start, ask yourself about, go to ChatGPT and feed yourself in and see if you're in there.
I started that way as well, by the way. The second thing I ever did was the PowerPoint. The first thing I ever did when I was just signing up for it, I was like, "What? I don't even know what to do here." I wrote, write a story about Trish Rich, and I put in my husband's name. My husband shares the name of a famous director. Christopher Nolan. He is always disappointed to find out he's not the famous maritime lawyer. Christopher Nolan's not out there talking about him. But anyway, it spit out this story about a movie about a legal ethicist, and I was like, okay, you're halfway there. And I think one of the cool things about ChatGPT right now is that what we're seeing is that it's confidently inaccurate.
Absolutely.
But I think to Damien's point, it's getting better so fast.
And I would say two things to that. You get what you pay for. That is, with Google, you are not the customer, you are the product, right? Like, Google is free because they use ads to be able to do that. So that is a free service. ChatGPT, the free version, you get what you pay for. So that's thing number one. Thing number two is, if anyone uses the tool as an extractive tool, saying, based on the internet, tell me what my bio is, it's going to hallucinate all over the place. That's option one. Option two is to say, here's a brief, summarize it. The hallucinations are going to be next to zero. So using it as an extraction, like essentially an information retrieval device, sucks. But use it as, here's a document, it's really good. Thing number three is, when I did cybersecurity, I would advise my clients, are you protecting the crown jewels, or are you protecting what you had for lunch today? Because everything is along that spectrum. So really, if the question is a legal research question, what are the elements of breach of contract in the Southern District of New York? That's like what I had for lunch today. People put that into Google today, right? What are the elements of breach? That's not confidential. So really, as you think about what is the confidential information I'm going in there, is it an innocuous legal research question, or is it the fact that my client's going to be in a merger with somebody with a major company? It's along that spectrum, so you should be thinking about where along that spectrum the data you're putting in is.
I'm not seeing any questions from the audience. Oh, here we have one. Okay. I was going to say, because I could keep going all day, but.
Hi. Thanks for the presentation. Bill Mergner, President-elect for New Jersey State Bar Association, and we're focusing on this in the upcoming year, starting at our annual meeting. And I've tried to go to a number of seminars to get my head around this. And I'm going to ask the questions that I think are the toughest ones that we're facing that I haven't heard good answers to from groups that are trying to market this. What do you say to, what I see when I see this is, we're never going to need associates anymore. You've already got a program that's better than 90% of the applicants that are taking the bar exam. And I see down the end it says, train your associates. Well, My kids had a calculator, so they didn't learn their times tables. They have spell checks, so they didn't have to learn how to do that. And all you're leaving is the more complex strategic stuff that they're not capable of doing. So how do they learn that? And then the second question is, and this is as a group that represents lawyers and wants them to flourish. And the second question is, when you're talking about ethics, you're focused on the unauthorized practice of law. But when you're talking about this as a tool to write a draft of a brief, you're putting client-protected information in there that we have ethical obligations. And the agreements that are drafted place all those obligations on us, where we're going to make lower profit because we're going to be restrained in the work that we're doing. You're going to make more money, but you're not subject to the same ethical considerations that we are, or have the same malpractice concerns if something goes wrong. How do you address those aspects of how AI is going to impact our practice?
I can address, and I'm happy to hear yours. So to go reverse chronologically, the business of law, as I mentioned, the hourly and flat fee, I think it's inevitable that we will move toward the flat fee. Will it be 100%? No. But you really can't bill and have our business model with 45 seconds of prompting. So if we move over to the flat fee world, the old world is how much did I bring back? What revenue did I make last quarter, last year? We don't think as much about cost in the hourly. But if we go to the flat fee world, if you shrink your cost, that increases your profit. So then we can actually make more money if it takes 20 seconds, because now we can be able to charge the same as we would have in the hourly model, and all my profit is right there. So if we think then, okay, let's move toward the flat fee model, then we have to say, what happens to the associates? Another thing that you're thinking about. When I was in 2002, the librarian said, you need to go to the stacks to look at the books, because that makes you a better lawyer. It didn't make me a better lawyer, it just wasted my time. Going to Westlaw, Lexis, VLEX, all these things made me a faster lawyer, and then I could focus on the more strategic things. So really, we have to think about, is that blank page problem really making me a better lawyer, or is it just wasting my time? And really, with my tool that we're building actually strategic questions to give that first-year associate, here are 5 strategic questions, so that first-year associate can jump from the previous tasks of what research should I do to the more strategic, let's jam with what we can actually do to win this case, or let's jam with the kind of transactional negotiations that we're able to do. So I think that it elevates the associates down up the level to be able to do what maybe a junior partner might have been able to do.
Julie, can you talk some about what Lexis is doing to solve the confidentiality problem of how are we going? I mean, the products that I hear that are coming to the market are pretty sophisticated and interesting. So I'm wondering if you can talk a little about that.
So one of the things that we decided to do early on, because of the confidentiality issue and security obviously being top of mind, is we have what I would call a closed AI model. So we work closely with a company called Anthropic, and it only, the original model that they sort of trained, we took that, it's closed, it does not speak to anything outside of our content set, which is a massive content set built up over years and years that is trusted and written by lawyers, and statutes and case law and all those sorts of things you're used to seeing in LexisNexis products. And so when you ask a question to our ChatGPT, Lexis Plus AI, or you put something in there that's, you would do this anyway with our other products, where you might type something in where there's worries about privilege, for example. It is only going, again, to our content to inform the decision. That's what the answer, I should say. That's what it's doing. It's speaking only to our content. So it's a closed model. You know it's only looking at things that you can rely on, for one. And the other thing is, with client data, again, it's this, we use AWS, for example, because security is top of mind. So we put in all the protections that we can possibly put in. We're happy to talk about those things to the public. And it's not, the other really big piece is that we don't actually use any of the inputs that the user would put in to retrain the model. We don't do that.
Which makes it different than a lot of the public-sourced generative AI
exactly.
products.
So that is purged when your user session ends. And that actually, interestingly, that is a question we've received quite a lot from bar associations. On
Good, I'm
our
glad to hear
product
people are
team.
thinking about that.
Yeah, no.
Yeah. We're going to talk
Right.
actually more about that in the second half on the ethics group. So we'll thank these guys again. We are going to start at 10:15 promptly on the second half of the presentation where we talk about ethics and misinformation. Thank you. Thank you to our speakers again.
Thank you.
Competent representation, keep abreast of the changes in the practice of law, including the benefits and risks associated with relevant technology. So when you talk about ethics, you often talk about the risks. And even notice, I think it was Damien's slide, right? He said, ethics, meaning like a prohibitory exclamation, like ethics, stop, bar, stop sign. But ethics actually isn't only a prohibition, it's also an encouragement and to actually think about how to best use tools such as AI in your practice. And in fact, as we all see, the standard of care evolves to require lawyers to do that. I mean, Damien started with email as being one of the early pieces of technology that we were all worried about. I'll go back further, faxes. Right? There was significant consternation about whether you could ethically fax. I mean, this just seems crazy now, and we are in that exact same place. So it'll be crazy a year from now, I think, to even look back at some of the things that we're talking about with respect to AI. But so again, we have to know the benefits of the technology. We do have to also understand the risks. And to understand the risks can be complicated when we're talking about an evolving technology and a technology that is not always transparent to the user. And frankly, are any of us technologists? Maybe Damien, okay, and he raised his hand, but I bet most of the rest of us are not. So to become competent and understand the technology, we're going to have to rely on other people. But just to keep in mind our duty of competence, I think helps get us part of the way. So some of the risks of using generative AI, we see this in the news all the time. It's too juicy for me not to just cover a couple of these. It's sort of, I just can't resist, and some of you will just want to remember these stories because they're really good horror stories. Frankly, mostly outdated at this point, and I think kind of obvious, but still, worth knowing just as a quick survey. So there's, I put 5 examples here of actual cases, 4 of which involve lawyers using usually ChatGPT, but in the case of Michael Cohen, he used the Bard product to do legal research. And in the course of that legal research, obtaining cases that actually don't exist. So the hallucinations that we've all heard about. And for all of these cases, at least the People v. Zachariah Craybill in Colorado, he ended up getting a very severe disciplinary sentence for using ChatGPT to generate cases, and then, well, he didn't know that it was generating cases. He thought he was researching cases. He cited him in a brief. Now, he got a very stiff disciplinary sentence, not just because of doing that, which I think we all recognize certainly fell below his duty of competence and probably his civil law duty of care to the client. But he also did other things. And in all these cases, actually, the lawyers compounded these errors by making misrepresentations to the court, not coming. In fact, he lied and said that he'd relied on an intern, for example. So, it's not just the use of the generative AI in ways that were not responsible, but it's also, compounding that error by further misconduct before the court. You're all familiar, I'm sure, with the Matta v. Avianca case. Again, lawyer using ChatGPT, but there again, did he stop at that? No, he actually didn't admit his use of the ChatGPT to the court. He didn't even follow up responsibly when the court ordered him. And in fact, when the court ordered him to provide cases that he had cited that didn't exist, he used ChatGPT to find them and then just submitted the excerpts, which weren't even real. So, but again, these are early mistakes. So that misconduct that we're talking about took place in February and I think April of 2013. The product has evolved since then, and of course our understanding has evolved since then. But there are a lot of ways that we can look at what he did, and no one's going to argue that he did something appropriate. In that case, he was sanctioned $5,000 under Rule 11 by the court and allowed to continue practicing, although he had to write apology letters to the judges whose ChatGPT misattributed the cases. So, okay, there's a lot to say. Ted, you can talk about the U.S. versus Michelle case, because that's an interesting twist. All right, so talking about the risks, we have to also talk about the benefits, and we've touched on that as part of the use cases today. There is a lot that ChatGPT can do. Generative AI. Look at this, all of us using it as an acronym. It's like Kleenex. But of course we have to understand, and we have to take advantage of those benefits. It's part of what our practice is going to evolve to. Duty of candor, this is the obligation to not to make false statements to the court and to only provide truthful statements to the court, et cetera. I only put this up here because there are a lot of court rules increasingly that require disclosure of use of AI. I think that this is a rapidly evolving landscape. I don't think these rules are going to stay. I think they're going to evolve. I've got some courts, for example, prohibiting pro se litigants from using generative AI. Damien shaking his head. Yes, access to justice issue, absolutely. Courts are grappling, though, with the very real problems that this all poses. So just stay tuned. And then lastly, I just want to say on the unauthorized practice of law, absolutely right, this is an evolving landscape. There's a lot of movement right now. At least there's a lot of challenge to the unauthorized practice of law regulation in this country. Some of it's coming from the access to justice angle. Much of it is driven by technology. And there's a tremendous amount of resistance by lawyers and various parts of the legal community. In California, I could talk for a long time about the battleground that we're experiencing in trying to expand our regulatory sort of options. And I won't do that here, but and many of you, probably if we took a show of hands, we'd probably be divided around the benefits of doing that. So just to say, I think that that's an area where we are going to see significant pressure and we are going to see significant development in the law. I'm not sure we're going to see significant development in the regulation for some time.
All right, I'm going to stop you there so we can switch speakers. And next we have Ted Claypool up from the ABA Task Force.
I'm going to speak a little more as a practicing lawyer and the practical issues that you need to think of when you're considering the ethics here. I think the main thing is don't be stupid, okay? I mean, that's a really basic idea, but if you put your name on something, you are responsible for it. And in particular, as lawyers, when somebody's asking me why the Avianca case and others are becoming famous and why lawyers are the ones being cited in all this, and that's very easy because we actually do things that you need to back up. They have facts in them, and we file them so they're public, and then somebody on the other side opposes them immediately, and so this kind of issue pops up right away. So you can't hide from it as a lawyer. Our good friend Roland Trope talked in Atlanta last week about generative AI, and there were a number of interesting things he said that apply here. One is that the AI that we've had pre-generative AI really does a lot of things better than any human could do, right? Its ability to swallow huge amounts of information means it can predict the weather much better than we could predict it because it swallows enormous amounts of information and it looks at strategy in ways that we couldn't. However, generative AI doesn't really do anything that humans can't do better. It does some things faster, as we were hearing, but it doesn't necessarily do them better. So what you're putting out there, the way Roland was talking about it, was you need to think about AI, generative AI like a second-year associate. right? If your second-year associate writes a paper and you're supposed, or a pleading or a motion, you're not just going to turn it in. You've got to review it. You've got to make sure that it's right. You've got to check the sites. You've got to make sure somebody does and stay on top of it. And this is what Mary's talking about in 1.1 in your essentially duty to competence. And so all of this is stuff that we've known for a long time. We don't expect that we're going to need new ethical rules around generative AI. Excuse me, because this is material that we've been dealing with for a long time. Similarly, if you're, and Mary mentioned, for example, the duty to manage and direct your associates and others, if you're, if you've got a paper going out and your associate writes it, or your secretary writes it, or the AI writes it, you need to make sure that you're on top of that. Now, there's another question as to whether or not you need to be telling your clients that you are using this tool. And there was the Fuji's case. I don't know if we saw that, but that in this case, the lawyer used generative AI to produce the closing statement of a case that he lost on behalf of a famous person who was a musician. And, the real problem there, and he was sued afterwards, not just because he lost, but because the reason he used generative AI to write this was that he had invested in the company that created this generative AI product. So there was a real question of conflict of interest. I mean, he should have, in some case, just written the thing himself, but because he had a famous case and he could talk about it, he decided to use a generative AI, pitch the company that he'd invested in, and maybe increase its value, which is, once again, stupid. Not what a lawyer should be doing. Because once again, you have a duty of not just competence, but of zealous representation for your clients. But then, as I said a little bit earlier, the question comes in as to whether or not you have the duty to tell your clients that you have actually been using generative AI. Lots of courts are beginning to put out statements, so you have to check your local court to see what they're saying that you have to be doing, because that is also part of our ethical obligation to make sure we're doing what we need to do appropriately for the court. And I just got an email this morning from somebody who pointed out a new court statement that said that you have to, in their court, if you're using generative AI models, you have to save and turn in the prompts that you were using so that the court can see what you were using to generate the material that you had. So, these are all things that we're needing to worry about right now. The next thing I want to talk about very briefly, because it'll get into what Lucy's going to discuss, is your duty of honesty, your duty not to lie to the court, not to lie to other lawyers. And this is becoming a much bigger issue with generative AI models. Why? Because misinformation is something that they do well. As we said earlier, because of, we've talked about hallucination, generative AI models, they predict. They are not actually out there finding information that's specific to what you're doing. However, they're very good at making stuff up. And that's great if you're a novelist or, I've become an artist as I asked the model to draw me pictures of, how a German expressionist would show a anthropomorphized buffalo at a cocktail party. I have some very good ones too. But the truth is that it'll create things that look like they're real and they're not, and those can be used as evidence. And you have two sides of this, and both of which you have to be careful of. One, you can't submit something like that to the court because it's a lie. And so, once again, stupid and wrong. And the other side is what we call the liar's dividend, which is that if somebody, for example, says, goes and shoots someone in the middle of Fifth Avenue, and there's lots of video of that, that person, he or she, might quickly be able to say, well, that's all AI generated. That's deepfake. And if we can't tell what's deepfake and what isn't, how do you know the difference? So it gives liars the ability to point to something. And so we're going to hear from Lucy now much more detail in this space.
Thank you so much, Ted.
Well, great to be here. My name is Lucy Thompson. I'm the chair of Mary Smith's AI Task Force, but even better, I'm a state and local bar leader, so I appreciate everything that you're doing in your state and local bars. I was a member of the Board of Governors of the DC Bar for 2 terms, and I'm a past president of the Women's Bar Association of DC. Today, we're going to focus on deepfakes, which is one of the most vexing problems facing the legal profession. But before I get to that, I just wanted to tell you that we have a beautiful new revised website for the AI Task Force, and we have a place to showcase your work. So we're trying to keep in touch with all the state and local bars that are working on AI. And we hope you'll keep in touch with us and let us know about your work and your programs, because we would like to put them on our website. So I look forward to meeting with all of you personally. So on to deepfakes. Deepfakes are a problem for the legal profession because it's having a profoundly negative impact on the courts. The FBI has declared that it's a national security threat. It possibly will upend the way litigation is conducted and the way courts operate. So this is going to be a lightning round through the issues of deepfakes. What are the threats? What are the impacts on lawyers? What are some of the regulatory approaches? And then what are some of the solutions? And I try to include a lot of references in here for materials that you can follow up on when you go home. So here's what the FBI and the NSA and CISA of DHS have said about deepfakes. Deepfakes are synthetic content that is basically fake materials generated by AI, and they can be images, video, audio, or text. And there's several reasons why this is a problem. The FBI has outlined 3: threatening the organization's brand, impersonating leaders and financial officers, and using fraudulent communications for fraud and theft. So here's another way that deepfakes are coming into the public knowledge, and through these sex texting situations that you've heard. Taylor Swift has been in the news. This is a huge problem. Congress held a hearing about this the other day. So these are major problems that don't have any readily available solutions at this point. So here's the impact on lawyers. Basically, the FBI has said that business identity compromise is a follow-on to what they called business email compromise, which is billions of dollars of losses have resulted because malicious actors and hackers have stolen money from law firms, from businesses, and they do this by impersonating members of a firm or members of a company, and basically compromising the brand, compromising you as lawyers, and stealing your money. So this is a very important DHS report. It's in 2 parts. The first part is about the problem, and the second part is about solutions. So I picked two scenarios that are really quite interesting and well done from this report. And this is about how malicious actors conduct social engineering attacks. And identity theft is a huge problem. These malicious actors go on the dark web and they get the most sensitive personal information about their target. Then they find like speeches or information on the web that they can use to impersonate your voice. In this scenario, the malicious actor actually contacted the company and they claimed to be the company official when they were obviously a hacker. They went through the voice verification system of the company, gained access to the financial accounts, and stole the money. So this is a very sophisticated attack, and we all need to be aware of and have protections in our law firms and companies for this sort of thing. And when you're advising your clients, this is something to keep top of mind. This is another report that's very interesting from the Brennan Center for Justice at NYU about disinformation and effects on elections, so you may want to follow up with that. So the next area that you may be interested in is about regulation of deep fakes, just so you know what Congress and states are doing. One example of regulation is the Deepfakes Accountability Act, and this focuses on watermarks, which are being developed by industry. And so this is just one of the proposed statutes pending in Congress. And then 9 states have started regulating deepfakes in different ways. And you can follow up with the National Center for State Legislatures if you want to find out more about this. And in the White House Executive Order 14110, which is about safe and secure AI, there's a section 4 which focuses on watermarks requirements, which NIST is working on. So next is AI in the courts. It's very important to know that this problem with deepfakes may undermine the way courts conduct authentication of evidence. And we don't have time to go into detail on this scenario, but you may want to study it. It pertains to a defendant in a murder case who created a deepfake of his whereabouts in a building where the murder took place. And the prosecution presented a similar video. So the defendant presented the fake video in order to undermine the credibility of the evidence that the prosecutor tried to admit. So this is a typical scenario that's a huge problem for the courts. So can jurors spot a deepfake? Well, the answer from most experts is no. And Judge Paul Grimm and Dr. Maura Grossman have proposed a change to the federal rules of evidence. And by changing one word in Rule 901B9, they're trying to give judges more flexibility in not necessarily presenting potentially fake evidence to a jury. So they changed the last sentence, which reads reliable to accurate. So you can watch that develop. And so combating deepfakes is the last point. The FBI has recommendations for how to deal with this problem. And if you go to this joint statement that we talked about earlier, you'll see some highly technical suggestions that you may want to consider for your law firm. That's number one. And number two is actually try to protect your own personal data and the data of your colleagues in order to avoid this problem. So here's some resources about deepfakes and the research in industry. And here's some cross-industry partnerships and work that's being done that's very important. There's no solution to this deepfakes problem now. So we all as lawyers need to be very aware of it and figure out how to address it.
Thank you, Lucy, thank you. And thank you to all of our speakers in the second half of the section. And again, our first half speakers, lots of information, and ending with Lucy in sort of this doom and gloom, like ginormous problem, we have no way to fix it, bye. So again, we're starting our Q&A for the second session of the program. We have a couple of people wandering around with microphones, so if you have questions, go ahead and get them ready, but I'll start with one. We heard a question earlier about whether or not this is or is not the unauthorized practice of law. This is the ethics panel. Tell us, why is this not the practice of law?
Okay, why is it not the unauthorized practice of law?
I'll be a little more fair. Is it UPL, Mary?
Well, it depends. Some of it might, and all of our states have, different regulations. In Alaska, there's a really clear definition of UPL, which is basically don't appear in court. Okay, that's kind of a good one, if you ask me. Yeah. But right, for most of the rest of us, our state's definition of practice of law, we don't even have a definition of practice of law. And that's true. And maybe some states might have a better definition, but we really don't even have a working definition. So can a regulator regard a lot of what we're talking about as actually being the practice of law? Absolutely. Part of that's a lack of definition, and part of it's, just the way in which UPL laws are utilized to protect and limit the availability of, the openness of our kind of legal marketplace to others.
Yeah.
Yeah, and I would suggest that Deloitte's been having unauthorized practice of law for 75 years now. I mean, it just depends on how you look at it and how you define it. And as we heard earlier, we're making the distinction for a while between, are you giving legal advice or are you simply doing legal research? And I think that's going to be a really big issue in AI models as it comes up.
Yeah, Damien, I see you with a microphone. Go ahead.
We've been talking a lot about being essentially what maybe you should not do because of ethics, but there's also an ethical obligation to be able to charge your clients a reasonable fee. So if I can take a 10-hour task or a 40-hour task and shrink it down to 2 minutes, is there an ethical obligation to use that tool to not charge my clients an unreasonable fee?
I'll jump in on this. So the question is under 1.5, because we are obligated to charge reasonable fees, do we have an obligation under what would be 1.5 and 1.1 comment 8 to use technologies to charge reasonable fees? I think Mary and I would both say, I don't want to speak for you, Mary, but none of these are new problems. These are all old problems that we've seen before over and over again. And this problem was particularly relevant when I started practicing law in 2006 because we had just started doing computer-assisted document review in the courts. And I am the best. I've heard that there's a group of people that call themselves the greatest generation. I disagree. I think if you were born in 1980, you are exactly the perfect age. That's me. Because we were born on the cusp of Generation X and the millennials. And so I had been using computers since I was like 6 years old, but also I can make myself food. So it's the exact perfect age to be. So when I started practicing law, we were just having these debates for the first time about, like, can computers review documents the same way we can? And we were seeing all these judicial opinions that were saying not only can they do it, they're actually much better than you guys. And we had a bunch of lawyers saying, like, no, we aren't. And the idea that we would today, in my 18th year of practicing law, spend, any amount of time reviewing 1 million documents in a true story, salt mine underground in Kansas City, that was my first business trip, is beyond the pale, and we would never be able to charge for it. So I think that we're going to get there very quickly on things like writing briefs. But
Well, I would also say it's a little bit reductionist to say, well, I can do this in 45 seconds, so how can I charge? Because it's not just 45 seconds. It's then the 2 hours that you got to take double checking and reviewing and making sure otherwise you don't want to be up on my slide, right? For the bad behavior. So I think that we will find a way to do it. I don't think it's not going to be any different than how we've done before.
go ahead. Can I get a microphone up here up front? Thank you.
Thanks. So, Damien, the answer to your question is that's exactly what the auditors at all the insurance companies said in 1990 when they came to our offices for the first time and said, how come you charge 0.6 for serving the same set of interrogatories every time? And the answer to that was we made less money. And we worked much harder to make the same money, and we still have the professional responsibility that goes with it. And when you mentioned Deloitte and the way that they engage in the practice of law, where I think the disconnect is, and I think if there's a path for lawyers in this, it's for the good of the public. We have all these rules that define our professional responsibility. The companies that are going to take advantage of this and profit from it have to be forced to share in that professional responsibility. These agreements have to hold us harmless, make them provide us insurance, rather than us in a state like New Jersey where we have mandatory professional malpractice insurance at a great cost and a 6-year statute of limitations plus discovery. We can't be put in a position where we're going to make less money to do this, and the companies that make more money don't share the professional responsibility. Is that a path that's being considered in the groups that are looking at this issue?
Well, absolutely. I mean, you've got the Utah sandbox looking precisely at how to regulate law technology companies and how to bring them in and what rules and how to apply the rules to them. In California, we were exploring that, and the legislature cut us off. So now we're just not doing anything. Does that mean that law technology companies are not operating in California? Of course not. So we're going to have to find a way to, allow the camel's nose under the tent so that we can bring them in and make sure that this is being done in a way that's consistent with our professional obligations, but it's going to mean changing how they apply. And you're absolutely right. We're going to be at a disadvantage if we don't figure out how to, what obligations should apply, how should those apply, and how is this landscape going to work?
Yeah, I think I'd add that, one of the things I think we see in the regulatory process is that the changes in our rules are often reactive, and this is just not a moment where we can be reactive. It's just not, this does not lend itself to reactivity.
So in California, is part of the problem on the regulatory side that the companies that want to do this are outspending us in lobbying on how to manage this, so we're not
No, the
running into
companies that want to
roadblocks?
do this are being shut down. It's the consumer attorneys, honestly, and I was the vice chair of the working group that was looking at this, and I have spent a lot of time, and I'm still working on these efforts. But frankly, it's the consumer attorneys, and they're very, very organized, and they are not going to, they're going to do their best to make sure there is no change in California. So the problem, and believe me, we have a robust law technology industry in California. They are not regulated right now.
Any other questions? Okay. What, in terms of supervision and well, I guess let me ask Mary, did you, I didn't talk to you about this before, did you read this new ethics opinion out of Florida this last week?
Yeah, and this was the last part of my slide
Yeah.
that I was cut off from telling you about. Thank you for returning to this, Trish. Just last week, there was an ethics opinion in Florida that was finally
our first one,
approved.
yeah.
This was the first legal ethics opinion that looks at AI, and it has guidance. There's also guidance from the California State Bar's Ethics Committee that came out a couple months ago. Very similar guidance, honestly. The site to that ethics opinion, I think I put it on the last slide, or maybe it was too recent for that last slide. It's worth looking at. It's something that, you guys are from all over. You might want to bring back and think about. Ethics opinions have the benefit of providing guidance in a non-binding way to lawyers, in your jurisdiction. And I thought the Florida opinion was, fine, nothing groundbreaking. I don't know if ChatGPT could have written one. I don't mean to criticize it. It's fine. And I think lawyers do need guidance. We're hungry for guidance. So the more guidance we can have available, the better.
Yeah, the opinion, I agree with you. I think it's pretty commonsensical. The one thing in there that I think is going to catch people's attention is it says, and remember this is an advisory opinion only, but I think we're going to see other states passing these pretty quickly. And when we do this next year, we're going to say, there's 34 of these. The one thing that's in there that I think is kind of going to catch people's attention is it says, you have an obligation to read the terms and the conditions and understand them of the programs that you're using and understand how they keep and store and collect data, which I think people are going to be like, oof, because we all just check the box and press, go ahead, I think, or at least I do. But again, that's not a new obligation. We have that obligation with any technology we use. And again, not a new problem. I mean, I remember us talking about this when we started using LinkedIn 15 years ago, and LinkedIn had the option of like, do you want to connect your contacts?
Cloud computing.
Right,
Do you know how many
cloud computing.
ethics opinions address cloud computing? It's like this huge list, and they all say basically the same thing. That's what's going to happen here. And it's not a bad thing. It's just, it's the same rules applied to a new context.
So,
Yeah, can I
Oh,
just
go ahead.
add, our AI task force has a risk mitigation group, and a lot of the members are looking at the terms and conditions of all the AI applications and the system cards. We're going to be publishing a report on this, so hopefully you'll find it informative and useful, and it'll shortcut some of the research that you need to do.
one thing that I've found is particularly an annoyance to me as we have gone through this process together is the standing orders and the court stuff. Because I personally believe we're seeing an overreaction from the judiciary. And to that I would say, the first time a lawyer showed up to court drunk, we didn't get standing orders from all over the country saying, oh, by the way, lawyers, remember you can't come to court drunk, right? And the mistakes that we've seen, while not ideal, I don't think they're out of control. So, but maybe I'm alone on an island. Any thoughts about what we're seeing out of the courts?
We have an AI in the courts task force, working group in the AI task force, and Maura Grossman and Judge Grimm published an article very recently in Judicature talking about these standing orders from the courts and basically suggesting that it may be unwise for the judges to be issuing these orders. And they have some really excellent explanatory material that you might want to refer to.
Yeah, these orders are coming fast and furious. Judge Brantley Starr, who was one of the first ones from the USDC Northern District of Texas, part of his order has a long preamble which includes this language: unbound by any sense of duty, honor, or justice, such programs act according to computer code rather than conviction, based on programming rather than principle. So there's a real concern on the part of the judiciary. Part of it is dealing with, all of the issues that we've talked about, and it's a very real challenge for the courts. But I think this is an overreaction, and they're going to have to pull them back because, for example, requiring lawyers to disclose every time they used AI. I mean, what's that even going to mean with like all of our LexisNexis products that use it? I mean, we're all using
Outlook
it right now.
uses it.
Right,
Exactly.
right.
It's not realistic.
Yeah, that one particularly irks me. There was one I saw recently that you have to tell the court if you used AI to generate something. And to me, I was like, I've never had to tell you when I had a first-year associate write something. And I hope we see some
Well,
pullback.
and it reminds me that there are some state laws around blockchain, which Steve Middlebrook, one of the guys in our group in cyberspace law, says is like having laws about Excel spreadsheets,
Yeah.
right? I mean,
Right.
do we like Excel spreadsheets? Maybe, but, if we really did, we wouldn't have been lawyers, we would have been accountants.
But the existing rules deal with the issues already,
Yeah,
and that's why, even
exactly.
when we've seen in this case
And
law.
why regulate the tool?
Right, we have existing rules that handle every scenario that we've already seen. So I'm hoping that we'll see more moderate heads prevail once we get over this like hump of like being very,
Panic.
yes, exactly right.
I think we're.
Okay, any other last questions? I think we're gonna wind up here, unless anybody has, okay, not seeing any. Thank you again to you guys, you've been wonderful, and the first group, and thank you to all of you for sitting through this. I hope you learned something. I hope you found something valuable that you can take back to your home states and use. And